I want to welcome everyone to another NAMI Davidson County virtual education session. NAMI Davidson County, as part of our mission, is to educate on mental health issues, not just spread awareness and offer free support. Free support. We also want to do education. We do education classes throughout the year. We have an upcoming family to family class in September that's starting. We'll be looking into doing peer classes too in the new fiscal year. But tonight's our chance to have one of our community partners and friends, Trish Breeding, come out tonight and talk about the mental health court system. So I'm going to turn it over to Trish for our presentation. Welcome, Trish.
Thank you. Hi, everybody. As he mentioned, I am Trish Breeding, and I work for the Davidson County Mental Health Court and Veterans Treatment Court. Tonight, I'm going to focus primarily on the mental health court section, as that's what I've been asked to talk about. But if you have questions about recovery courts in general at the end, or even maybe the general court system, I'm not a lawyer, I'm not a judge, I can't give you legal advice, but I can help you to figure out maybe some of the burning questions you have about the justice system and bring you some peace around some things. I want to start, let's see if I can get it to change, about what is a recovery court. So back in the day, many, many years ago, in the early 2000s, maybe even the 90s, people started having these things called drug courts pop up in and around the country. And for many years, if you had an addiction issue, you could enter a drug court instead of the traditional court system. So very similar to a drug court, the development of other types of problem-solving courts came about, and they're all sort of under the umbrella of a recovery court. But you have now several different types. And in Tennessee, there are about 90 different types of dockets that are judicially supervised treatment courts. The intention of those is to decrease the correctional cost. They also teach people how to live inside their community. And really, once a person is more stable, whether it's their mental health or their substance use issues, it really benefits the community as a whole. Every single jurisdiction sets their own scope of practice or who we serve. But overall, what we are taught to serve are people who are high risk, high need offenders who are willing to voluntarily enter the program. And I'll go into what that means a little bit more later. Mental health courts, recovery courts in general, are not a get out of jail free card. In fact, it's much more difficult for a person than just laying down in a jail cell and doing their time, or getting out on traditional probation where they just check in pretty infrequently and do the bare minimum. Our folks are very busy trying to get their lives in some sort of an order. All of our programs are voluntary. Any person who wants to sign up for the mental health court or veterans treatment court have to do so willingly. But the ADA, or district attorney, as you may know them, the defense counsel and their originating judge all have to agree to send the cases to the recovery court. So the reason our courts are voluntary is, I'm an adult. If I have a diagnosis, I can say, I do not want to take medications, and I have every right to do so. But when you come into a mental health court, you are giving up that right, and you are saying, I will see a psychiatrist and I will take all medications as they are prescribed. So you're sort of losing some of your autonomy by coming into the program. So it's very important that we explain that to people on the front end. This is just a little one-pager that the state of Tennessee provides that talks about the number of recovery courts and where they're located and the funding. The numbers that you're seeing are not updated. The state had a huge push recently to identify jurisdictions that could benefit from a mental health court and grow that number. So we are seeing more and more recovery courts for mental health issues popping up across the state. There are other down at the very bottom, you'll see residential recovery courts. A couple others of those now exist that are not indicated on that form as well. So I can answer questions about that at the end if there are any. Just a little bit picture of what's available inside of Davidson County, since we're talking specifically about what's offered here locally. As I mentioned, I am the assistant director of the mental health court and the veterans treatment court, but also in our area, there is a DUI treatment court for people who have multiple DUI offenses that can go into that program. And there's your traditional recovery court, and that serves people who are substance use primary, meaning they may have some mild mental health issues, but really they need help getting sober. And then Athena's Court is something that is available in Davidson County, and there are no other programs like it in the state and very few across the country. It is actually a treatment court focused on people who have been human trafficked, specifically sexually trafficked. So our community is right here in the hub of all these interstates and is a big metropolitan area. We see a lot of issues around human trafficking. So several years ago, that was developed. Mental Health Court Treatment Act of 2022 is what officially started mental health courts in the state of Tennessee. I say officially because Davidson County was a pioneer and actually started their mental health court, I believe, in the year 2000. I came on board as a case manager for a community partner in 2004, and then started working in the actual mental health court in 2007. So I've been around quite a while. It just didn't get recognized by the state in the same manner as a old school drug court. Mental health courts were set up to serve individuals that have been diagnosed with a severe and persistent mental illness. Based upon state law, we can't serve people who are convicted of any type of sex offense. We can't serve anyone who is a violent offender that is defined that way under TCA code. And we are a non-adversarial approach, meaning you see all of these court dramas on TV where lawyers stand in front of a judge and argue. In our courtroom, that does not typically happen. It has happened, but it's a rarity. We do a treatment team every week before our court hearings, and we argue behind the scenes with a door shut where the clients don't see us. That way, when we get into the courtroom, there is a united front. That doesn't mean that the client loses their rights. That doesn't mean that they don't have an attorney that will speak up for them. We have both of those things available. We just try not to be argumentative in front of the clients. We want them to feel comfortable. We want them to know everybody's on the same page to help them, that kind of approach. I'm a little bit of a rebel at times, let me just be honest. So TCA code 1622-103 talks about what a nonviolent offender is. And several years ago, some genius within the government decided to alter and amend that TCA code and added the highlighted part that you see where it talks about is convicted of a domestic assault under Tennessee Code 3913-111. Prior to, I believe it was 2020, that was not in the definition of a nonviolent offender. So theoretically, this decision by our state legislature made it so that mental health courts, drug courts, DUI courts, all the recovery courts really were unable to take anyone convicted of a domestic assault. So that means even if 10 years ago I picked up a domestic assault, today it would make me ineligible for a recovery court program. And I've been working in this business long enough to know that's hogwash. And so I just ignore it. And I haven't gotten in trouble for it yet, but it could happen. But we all know that when someone is having a mental health emergency, typically the first person that gets harmed, if someone's going to get harmed, is a loved one, because that's where the person is living, or that's where the person feels safest to, let whatever out. And I don't believe personally that someone should have that held against them. So our court does, the mental health court and veterans court both take people charged with domestic assault, even though we're not supposed to. Other recovery courts do not. So mental health court has a process, and I'm going to walk you through the application process here in a little bit. but anyone who applies needs to be someone who has a severe and persistent mental health issue. Um, I don't want to sound flippant about it, but our program is not intended for people who have, depression because they're going through a divorce or grief or something that is not long term. Typically, it needs to be something that has impacted their life significantly for a long period of time. We do accept people who have co-occurring disorders, whether it is a mental health disorder as well as a substance use disorder. We also will accept them if their co-occurring disorder is a TBI or traumatic brain injury, autism spectrum disorder, or some intellectual or developmental disability. We will not accept someone solely based on a TBI, autism spectrum disorder, intellectual disorder. A lot of times we get referrals for people who have dementia. That's a medical illness. Even though a lot of those illnesses are listed in the DSM, we focus on things that we can treat and get the person back on track. And oftentimes, if those are the primary disorder, our program is just not set up for that. In Davidson County, our program has 2 tracks. Earlier, you heard me say that recovery courts are set up for high risk, high need individuals, and that's true. But what I realized several years ago is that if I'm only taking people who are at high risk of recidivism, that is not serving a huge portion of the community that deals with mental health issues. Because what they're not taking into consideration, and I'll go through the risk needs assessment information shortly, but if you are high risk, typically you've been arrested before. You've been in the system for a little while. You're not getting or picked up on your first arrest. But the people that I want to help are the people who have recently been diagnosed with schizophrenia, who have had their first psychotic break, and as a result of that may have been picked up by the police and charged with something. I believe personally that those individuals deserve just as much treatment and care as someone who's been involved in the system for a really long time and has a well-documented issue with mental health, within the criminal justice system. So many years ago, we started working on developing a lower risk, high need track. The difference in that is really supervision. The people who are deemed to be high risk and high need are in the program for a minimum of 18 months and 5 phases. And they're really seen more frequently by both the judge and our staff than those who are deemed to be a lower risk. They still have high needs. They still have a lot of things that they need help with, but maybe they're at less risk of picking up a new charge. And when I talk about risk, it is based upon recidivism in this scope. So the lower risk people are with us for a minimum of 12 months and 4 phases. We have Judge Melissa Blackburn, who presides over our weekly dockets, and those are on Tuesdays at 1 o'clock and some Fridays at 8 a.m. We serve individuals that are 18 years old. We do not work with juveniles at all. There, to my knowledge, used to be a family court at juvenile. I believe it's still there, but those worlds don't typically mix. We serve nonviolent offenders, like I said earlier. Put an asterisk by that because I will take a domestic assault. And you have to live in Davidson County. Now, there are exceptions to that rule. I will tell you point blank, we have been known to take someone who lives just over the county line if we are the closest mental health court and they have transportation to get to us. I want to try to help as many people as I can, so I've sort of broadened the net and made some allowables that historically we've not done. Things that make you automatically ineligible. The big thing is if you have ever been charged with any type of homicide, that means attempted homicide, vehicular homicide, first degree, second degree, any of the above, we automatically cannot serve you. If there is a use of a firearm or really even the use of a knife in the crime, now that doesn't mean that they had a pocket knife in their pocket and they got charged with possession of a weapon or something. we will still work with those. But if there was a gun used in the crime, or if someone got shot or stabbed, we will not get involved. And the big other one is sexual offenses. If the person has been charged with or convicted of a sex offense, we cannot work with them. There is a caveat to that, in that if you are unclothed and urinating in public and get an indecent exposure, that can sometimes be considered a sex offense. We read the affidavit and see what was going on. If the person was just disheveled and maybe took their pants off in a moment of unwellness, then we take that into consideration. But if it was sexual in nature, we do not get involved at all. The other big one is arson. So this is not necessarily for the reason that you may think. The thought of someone setting a fire isn't the scary part to us. It's that we can't find them housing. People who have been charged with or convicted of reckless burning or arson, typically housing placements will not accept them into the program. So we are not able to house that person, and we don't want to set them up for failure. A lot of A and B felonies are typically ineligible. That would be like major drug charges and things like that. But we will look at stuff on a case by case basis. If there's, the DA is saying, hey, the victims are saying this person has a mental health issue, we really want to get them treatment. We will look at it on an individual basis and see what we can do to help. But for sure, homicide, the use of a firearm, and sex offenses are ruled out. We talked a little bit about people who live outside of Davidson County. They are automatically excluded, but like I said, I will make arrangements on those if I can at all. We have a girl currently who lives in Rutherford County who participates in our program, but she lives just across the county line, and it's easier for her to do that than other things. If we get a referral and they have a hold or have a warrant in another county or another state, we can't move forward with their application until we can get that figured out. Oftentimes that doesn't automatically come with a no. It's where I will tell their attorney that we need to figure out what the other county is doing and work together. And oftentimes what that results in is us supervising cases from Wilson County on top of Davidson County charges, or Williamson County and Davidson County charges. And then we just send a monthly report to those other counties so they know that the person is doing what they need to be doing. And they cannot work as a criminal informant while in the program. If you have somebody who's trying to get sober and mentally well, the last thing we need them doing is out doing controlled buys for the police department, where they have access to the drugs that we are trying desperately to keep them from doing. So those are the big ones. Some general information about how we operate. Whether you're in track 1 or track 2, we do frequent and random drug screens. Most of our people are co-occurring. We have probably 15% of our folks who have never used drugs or alcohol or don't have a problem with drugs or alcohol, but about 85% overall are co-occurring in that manner. So we want to make sure that those individuals are staying sober so they can be well. We require them starting out to come in once a week to court. Their court dates are based upon what phase they're in. So as they progress through the program, they're seen less frequently by the judge. The entire time someone is with us, they have to see a psychiatrist and they have to see a therapist and take all medications as it is prescribed. This is a basic requirement. I go over this with people 100 times before they ever enter the program. And this is the number one reason people end up in trouble in our court, because they start feeling better and they don't want to take their medicine. And then it starts a big problem when things start blowing up around them. We do home visits for our clients. We want to make sure that they are in safe housing, have a roof over their head, a bed to sleep in, a refrigerator full of things. A lot of times our clients start with us being unhoused, and we get them in group homes and halfway houses, or some of them live with their families. And not not everyone can tell you that their house is unlivable, because to them, they've always lived in it and they think it's okay. So we want to make sure that they are provided for and in a safe environment that is drug and alcohol free. People who come into our program have travel restrictions. Specifically, they cannot leave the Davidson County area without the judge's permission, and she does not give that out very quickly. Typically, you have to be in phase 3 before she will let you travel. And then it's typically for one night, sometimes two, to see family. But if you're just planning a beachfront vacation, she's not going to let you go usually. We are an incentives and sanctions based program. So as you start out in phase 1, and as you're doing all the things that you need to do, you're getting praise from the judge, praise from the team. We do these cute little things called doggy dollars that have, Judge Blackburn has a little, I don't know what kind of dog it is, a little white, cute, frou-frou dog. And its name is Abigail. So we have doggy dollars that have a picture of Abby in the middle. And when a client does something they're supposed to do, each team member has a different color. So you can kind of keep up with how many, and who gave it to you. They can turn those in to get out of court early, to get seen first, to do virtual meetings, for gift cards and different things. But we also sanction people when they're not doing what they're supposed to do. And that can be anything from the judge fussing at them to writing a report, all the way up to jail time if they're not doing what they're supposed to. And we've sanctioned them in other ways first. We don't typically lead with jail time. We try to stay away from that the best we can. But sometimes we don't have a choice. We take cases that are open, meaning the person has not pled to them yet. And if they complete our program, they can be dismissed and expunged, or closed, meaning they're pleading guilty to a charge and then being sentenced to mental health court for supervision. We also, it's not on the slide, but we are a general sessions court, but we'll also supervise felony charges. So we do supervise things out of what we call criminal court or state trial courts. When I talk about a severe and persistent mental illness, I'm going kind of by the old school listing of them. We serve people who have been diagnosed with schizophrenia, schizoaffective disorder, bipolar 1 disorder, major depressive disorder, as long as it's severe and has been long-term. If it's a single episode, or if it's, mild, like moderate, and it's just a single episode, we typically won't serve that person and will refer them to traditional avenues, just because they may not fit inside our scope of practice. And you do more damage putting people into a program that don't belong than excluding them on the front end. We've learned that the hard way, I assure you. We take PTSD, especially if psychosis is present. If it's more mild symptoms of PTSD, we typically will not serve that person. The same thing with bipolar 2 disorder. When it's more persistent and severe, we have been known to take those cases when the person is really having a hard time and their disorder led to their arrest. I said a little bit earlier about the risk need assessment. This is a new concept for a lot of people, because when I say risk, most people think, they're at risk of relapse, or they're at risk of getting off their medicine. But this is a very specific situation that the state of Tennessee makes us look at so that we can decide if someone should be in our program. It is actually looking at the risk of recidivism or rearrest. We use something here in Tennessee called the 10-RISE. It's adapted from the Ohio Risk Assessment System, and all recovery courts across the state of Tennessee use this. We are required to by the state if we get any funding. It is multifaceted. It includes questions about their personal history, their substance abuse history, financial background, criminal thinking, all kinds of questions that they get really upset with me for asking, but I have to do it. What I can tell you about the 10 RAS is that it does not take into consideration mental illness, which can be problematic. We counteract that by getting people's mental health records so that we can document why they may be at risk of recidivism due to their symptoms and can override the traditional 10 RAS score. It also doesn't do a great job of measuring the risk of recidivism for DUI offenders. There are tools out there that do a much better job. So we have added the use of something called the CARS tool for DUI offenders, just because we want to make sure we're putting people in the appropriate place. The first thing you're taught when you work in recovery courts is do not mix low risk and moderate risk with high risk people, because what's going to happen is the people who are low risk or at moderate risk of recidivism are going to learn all the tricks that the high risk person knows, and they're going to come out of it high risk because they're going to then be doing the things the high risk person does. So we try to be mindful of that. Requirements. Like I said, we make sure that everyone is seeing a psychiatrist and taking all the medicine that they are prescribed. We have a really good working relationship with the two, I don't know that they're the largest, but I think they are the largest providers for Medicaid and uninsured folks. So Centerstone and Mental Health Cooperative both come to our dockets and are present in our treatment team. They have an MOU with us so that we can openly discuss our clients, their medication, their appointments, all that jazz. Clients have to see a therapist as directed and engage in treatment sessions. So I will never know what they talk about in therapy unless they threaten my life. But I do know that they go and they engage with that therapist and they talk about all the things going on. If we get reports that they're going and they're not engaged, then we start really using some motivational interviewing to try to problem solve why they're not comfortable and see if we need to get them a different therapist or what the problem is. And you all are the first ones to hear this, but we have recently signed an agreement with Park Center, and they are going to start offering therapy for some of our clients that can't get it elsewhere. There's just not a lot of agencies that take some of the marketplace plans, and we have really struggled trying to find therapists for folks. So this is hopefully going to bridge that gap. The people in our program, like I mentioned, are drug screened a couple times a week. We do urine drug screening, and that way we can monitor for abstinence. And it's not about catching them so they can be sent to jail. It's about catching it before it gets out of hand and addressing it, getting the treatment, because we all know that if someone has a substance use issue and they take up using, it's just going to make the mental health situation even worse. And we don't want that. They are assigned classes based upon individual needs. So specifically in our court, every single person has to do a peer support class. So we recently hired a certified peer recovery support specialist who is actually a graduate of a mental health court. And she does a class or group with all of our participants when they are in phase 1 and phase 2, and then they can continue that group if they want to after phase 2. We also use her to have individual meetings with people who maybe need a little extra encouragement or have some questions about goal setting or, just how to navigate the program. We also do an MRT class that is to address criminal thinking. So for those participants who have maybe been engaged in the criminal justice system quite a bit and their way of life is that of a criminal. It's just a way that we adapt to survive. Honestly, that's what they've done. And we have to rewire that. So we put them through, it's typically an 18-week class about that. And then they have to have regular contact with their client specialist. And our client specialists wear 2 hats. They are first and foremost a public safety employee, meaning we have to ensure the client is safe and the community is safe. If we know our client is out doing heinous things, picking up charges, we have to do a warrant. But before we do that, hopefully we can catch it before it gets to that point and offer therapeutic solutions and do case management with them to avoid that type of intervention. In our court, the client will receive case management from us as well as whatever community provider they see. So whether it's Centerstone or Tennessee Voices or Mental Health Cooperative or a private psychiatrist that through their insurance or Vanderbilt or whoever, they receive services there, but they will also receive case management in our office. We refer people out for alcohol and drug counseling. That can also include any type of outpatient, inpatient, residential drug and alcohol treatment. We refer people out and now probably to Park Center more often than not to therapy. Inside our office, we do MRT, anger management, seeking safety, peer support group, and then I am licensed in AccuDetox. I've learned that most of our mental health court clients are not big on that idea, but I really wish I could get them on board. It's a very helpful service for a lot of people, including myself. I started getting it done and then got licensed to do it because it's been so beneficial. We provide referrals to community-based services. One of the blessings, and also a curse, I guess, is that Davidson County is so large and there's so many community resources that we outsource most of our stuff. When you get into some of the other mental health courts, they really have to be self-sustaining and have everything on site because they're in rural communities. But with Davidson County, there's so many things out there in the community and they're ever changing that we are constantly referring people to different places, whether it's for a food box or for housing or, hey, this person needs some shoes for work or job training or anything under the sun. I have moved people. I have been in the labor and delivery room with a client because she didn't have anybody going with her and was scared. We've done it all at some point in our office. I've babysat. We try to take away all the barriers that can prevent someone from getting the help that they need. How to apply. So we are a no wrong door type of place. A person can be referred by themselves. They can say, hey, I would like to do it. Their family member can do it. We will do it over the phone. If we need to, you can walk into the office. You can apply online. We take court referrals. So the defense counsel, the district attorney, or the judge can all request it. The jail staff can say, hey, I've been seeing this person in the jail for mental health needs, or they can be at the BCC and they can say, hey, I think they need added support. We also get it from MTMHI when people have been sent out on a forensic evaluation and been found competent. Oftentimes they will then say on their letter or on their addendum that the person may be appropriate for mental health court. Another option is when the officer is on the scene of the crime. So let's say I call the police because my husband is unwell and something has to be done. The police come out and he ends up arrested because of whatever's happened. The police officer can write on the affidavit that the person is clearly having some mental health issues. The family's saying there's mental health issues and they're interested in mental health court. And a lot of times that will trigger a referral in the court system. I've also had police officers call me and say, hey, I took such and such in last night. Do you think you could give them a look for mental health court? Community referrals. We've received referrals from DCS, from social workers at hospitals, from mental health case managers at like Mental Health Cooperative and Centerstone. They will call and say, hey, such and such on my caseload got arrested. Do you mind looking in for it? So really there's no wrong way. I try to be upfront when I see something that makes someone ineligible or that might be a problem. Sometimes that ruffles family members' feathers a little bit, but I just really like to be honest and forthcoming. I don't want to get anybody's hopes up that I can work a miracle that I can't, and then it all crumble down later. So sometimes I may be a little bit frank about it, and that's just because I want to make sure that you know the reality of the situation. I know that Dawn is going to send out the slides. On this slide, you can see at the very bottom the web address so that you can make a referral if you ever need to. I want to talk to you a little bit this slide is about what happens after the referral. But I want to talk to you a little bit about the process leading up to the referral, because I think that it is very important. And there may be some questions about what happens when my loved one gets arrested, or what happens if I get arrested. And so I want to walk you through, with general terms, how we get to the point of referral. So if I were to be arrested tonight and I am in jail and unable to make bond, I will be on a jail docket within just a couple days. It's typically the following day, but on weekends, it would be Monday. If I get arrested, Friday, it's Monday. If I can't make bond and I'm on that jail docket, I'm appointed an attorney unless my family goes out and hires someone to represent me. But typically, if the family can hire an attorney, they also will make bond for the person to get them out of jail. So what we see a lot of is appointed attorneys and public defenders, which I will tell you are oftentimes the same attorneys people pay for. It's just they happen to be in the courtroom and take appointments. So just because your person is assigned a public defender or assigned an appointed attorney does not mean that attorney is a bad attorney. I assure you of that. I've seen some great ones be appointed. So at that point, if your loved one says, hey, I have schizophrenia, that attorney, theoretically, I hope, knows about mental health court and can say, well, let me see if I can get you in mental health court. And they talk to the district attorney and they try to figure that out. A lot of times I will then reset the case to another day so that I can go into the jail to see your loved one and do the biopsychosocial assessment, gather information, and see that they are appropriate for mental health court. If your loved one is able to make bond and they hire an attorney, or they go and they get an appointed attorney or a public defender or whatever, I don't see them as quickly because their court date is set out significantly further because they're not in jail. So sometime between the arrest and their first court date, there really needs to be a discussion. And even during that time, I can take referrals from the family about, do you want mental health court with their attorney? And they can make that referral. If they don't do it on the front end and your loved one or whomever takes a plea and ends up on probation, and they're not doing great at probation and they end up violating probation, we can take a referral from probation as well. So just because there's a probation violation involved does not exclude your loved one from being considered for mental health court. I mentioned earlier that cases can come over in a lot of ways. I think it's important to note that if I am unhoused and I am living, I'll give you an example. I park on Gay Street at work every day, and that's the road right by the river leading up to the courthouse here in Nashville. And there is quite a bit of unhoused folks living in that area. And let's just say that I get picked up because the police come through and I'm asleep on the sidewalk and I'm blocking the passage. It's called obstruction of a passageway. We call it a homeless charge because typically the people you see who get arrested for that are unhoused. That charge can't be sent to mental health court because by law, it's a 30-day case, meaning the maximum sentence on that is 30 days in jail. Davidson County doesn't even do that. They pop them right back out because they try not to. I think they've done a really good job of trying not to penalize people for being unhoused or mentally ill in that way. But for a case to come to us, it has to be for a minimum of 12 months or a minimum of 18 months. And a 30-day charge doesn't meet that criteria. So there's some wiggle room on that. Like a 6-month case sent open, we can keep for longer if we need to, so we can kind of get around it. I don't know if I'm getting in the woods. I don't mean to do that. But once that referral comes in, it comes to me. I look it up in a program called CGIS, which is the clerk's system, so I can see what they've been arrested for, their arrest history, all that jazz. And then I look them up in JMS, which is the jail management system, to verify there's no holds and that there's nothing that would preclude them or exclude them from being in the program. I then will do the assessment. If they're in jail, I'll do it within a day or two. There's times where I'm out of town or something like that, but for the most part, I'm pretty quick about getting them done. Like this week alone, I think I've done 8 assessments, or we'll have done 8 by the end of the day, Friday. Once the assessment is completed, I will let the attorney know I've done it. This is where I'm at. Let me get the records, whatever. If the person's out of jail and their court date's 3 months from now, I'm going to see them within a month of that court date, because the assessments are only good for about 60 days. And I don't want to have to reassess them 2 or 3 times leading up to a court date. So if there's a lull and you think I'm not moving fast enough, it's typically because their court date's in September and I'm going to wait till August to see them rather than seeing them in June and then having to see them a second time. But again, that's just for people who are either out of jail or if their case is a felony and it's been bound over to criminal court, which you may have questions about, and I can answer that. Also, when you get these slides, you will see the QR codes. If you are super hip and cool and not an old person like me, you can scan the QR codes with your camera and it will automatically take you to the application online and you can fill it out. Those, like I said, they come directly to me in my inbox and to our administrative assistant. So she or I will reach out to you typically within 24 hours, 48 at the most, if we're both off work for some reason or out of town for a conference or something. But we try to stay on top of those and make sure everything is taken care of. Every 3 months, this is my favorite part. It's my favorite day. And I wish I had a picture, but every picture I could find had a client's face in it. And I try really hard to maintain their privacy unless they tell me otherwise. We have a graduation. We call it a commencement, a graduation. And to me, it's important because a lot of our clients have never finished anything. They never finished high school. You know, like they may have went to kindergarten and had that cute little graduation picture with their little cap and gown. But many of them have never really accomplished a lot. And I am so proud of them. And I think they should be so proud of themselves. And their loved ones are proud of them. We want to celebrate that. So we have a cake, we have punch, we line them up in front of everybody, bring them up, give them a certificate signed by the mayor and the judge, give them a challenge coin, and really celebrate them and give them the opportunity to speak freely. We've had people get up in front of people and say, I don't like Trish Breeding, she is hateful. But we've also had people get up and really talk about how much their life has improved as a result of being held accountable and also having someone hold their hand while they're doing the hard work to get in a better place. There was a time in my life where when my family would come into Nashville and we would walk around downtown, the majority of the unhoused people were people I knew from the court system. And, you know, I'd stop and talk to them or, you know, have conversation with them. And then I'd see them on a docket here and there and all the things. And several of those people have been through our program over the years and have much improved their life. And I want to be really clear. A lot of people will measure our worth on recidivism alone. Like, oh, you had blank amount of people rearrested. That's true. But when you have someone who's on the 50 most arrested in Nashville list every year, and they're getting arrested 112 times a year, and then suddenly you get them in mental health court and they've been arrested twice in a year, that sounds like a win to me. I don't know about y'all, but to me, that's a win. If I have someone who is chronically unwell and who has not been on their medications for 5 years, and we get them connected to an agency and get them started on their medication, even if they get rearrested, they have a better quality of life. So there's wins that when you are working with mental health court aren't traditional wins that we stack up. So it's not perfection. We don't expect everybody to suddenly be symptom free. We don't expect everyone to be perfect, but we do expect everyone to try really hard to live their best life. And we get to see that at graduation. So it's just my favorite thing in the whole wide world. And I just wanted to say thank you. This is my information. It has my email address on it because that's really the easiest way to get a hold of me. I'm in court a lot of the day and I'm running around with folks. So email is the quickest way. I also listed my mobile number. You can text me, just tell me, hey, call me. I'm such and such. I was with NAMI or whatever. But if I don't answer, it's because I'm in court or in somebody's house or in a session with somebody, and it's just hard to catch me. I'll be the first one to admit. Okay, so that's my presentation, and I know that that was a lot of information, and I left out a lot about the court system, but I'm willing to talk you through whatever might pop up. So I'm going to stop sharing my screen so that I can see everybody. And if you're comfortable, feel free to ask me a question. If you're not comfortable, I'll go into the chat or Don can narrate it for me, whatever makes you guys happy.
I don't mind narrating for you. And I'll be the first one to thank you for the presentation, Trish. This is a lot of good information for our members and the public, as this will be put on our YouTube channel. But Bella, would you like me to read the question or would you like to take this chance to do it yourself?
I'll go ahead and take it. Yeah, I just wrote it in the chat when it came to mind, so I didn't forget it. But earlier on tonight, you were talking about, the levels of severe mental health conditions that people have in order to be eligible for mental health court, and I was just wondering if you have found if there's been any situations where people may not have these diagnoses, they haven't had access to getting that level of care before. And what do y'all do when that happens? Do y'all help provide people get those connections to get these diagnoses to be eligible for your courts?
So I'll answer that in two ways. We do have experience where folks come into the judicial system who are experiencing their initial psychotic break or their initial, symptoms, or I guess maybe not even their initial symptoms, but the first time that their symptoms have been so incredibly crippling that they end up in a jail cell. And in those instances, we will sit down and talk to them and try to get them seen by the mental health provider in the jail quickly so that we can get a diagnosis to work off of. Now, if someone comes in and they're 56 years old and they suddenly have psychosis, that's pretty rare. It's just a rare thing to happen. There's usually something that comes along well before the age of 56. So in those cases, if they're in jail and they're experiencing psychosis, I'll still try to get them in front of a jail provider to make sure that their symptoms are addressed. And we have a really good relationship. Mental Health Cooperative does the mental health services in the jail. And, just your average Joe doesn't have access to the social workers and stuff there. But we all work pretty well together, and I can just email over to the person in charge and say, hey, I saw this person. This is what's going on. These are the symptoms I noticed. This is what he or she said, blah, 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 and get them seen. Now, 9 times out of 10, it's very rare that we see someone who has not at some point been touched by some mental health system. Like I said, first experience with severe symptoms we've seen, early on. But the majority of the people that I see have really extensive records. Like by the time I get done pulling records, their files are, this thick. Because they have been in the court system before and they didn't want mental health court because it is so much work. And they were like, oh, I'll just take regular probation, or, oh, I'll just lay down and do my 1129. That's really only about 9 months and get out and do my thing. Or I'm not ready for help, or I don't want to take my meds. So they've been seen in jail then, and then also may end up in mobile crisis, or somebody saw them at Vanderbilt and they were admitted for medical, but there was also some mental health to it. So typically I can get access to some records and get them there. If there's truly symptoms being reported, I will do my darndest to try to get them seen.
Thank you so much. That was really informative.
You're welcome.
Do we have any other questions for Trish? This is your chance. Don't be shy tonight.
Well, mine's not a question. I just wanted to make a statement about that because I know that we've kind of had this come up too. I think with even since I've been at NAMI, but so to that same point, Bella, because I really liked that you asked that. If someone is arrested for the first time and the parents are had been noticing like this like severity of mental health symptoms starting and it ended in like an arrest and maybe they've never had mental health treatment. I still think for those that are here, like it's important to call Trish and say, these are the symptoms. I want to make this referral. These are the symptoms. And then if they're still incarcerated, they can be seen. Like she can like say, okay, well, if there's never been a diagnosis, we can get them seen in the jail, or the parent can advocate for, or the loved one can advocate for them to be seen in the jail. And then it can go that route too. I wanted to mention that there's that kind of other side of it that like, because we have heard that at NAMI where, you know, this is their first, maybe they're 19 years old and their arrest was because of the severity of the psychosis or the threatening behaviors to the parents or whatever, you know? So there are ways that the parents and the community can also advocate for them by just making the referral, and like Trish can either send them to a certain place in the jail, or maybe they can call Xadria or whatever, you know?
Yeah. And I think, Ashley, if I can build off that just a little bit, I want to give an example that's not incarcerated, because that's typically what I run into, where someone has not been medicated or in services for a really long time and are still in the community. Like today, I did an assessment for a young man who's out, has a full-time job. I don't know that he would self-identify as, or he tells me he has a diagnosis of schizophrenia, but he doesn't really understand that diagnosis. No one's really talked to him about it, I don't think. And he can identify that he has some psychosis from time to time. Let's leave it at that. But he decided he didn't need medicine. And so he has not been seen by a mental health provider or been on medication for over a year. And the symptoms have gotten worse along the way and then led up to him being arrested. And he made bond and he's out on bond, but he has not made any move to get back into services. So what I told him today was, I'll go ahead and do your assessment. We'll gather all the information. I'll start gathering your historical records. However, what I need you to do is decide today where you want to go for mental health treatment. You don't have insurance, so these are your options. And let me help you to make an appointment so that I can get you in, get you medicated, and we can start the process. Because what I won't do, and this may be controversial to some, is I do not want to take a client into mental health court who says, yeah, I'll take my medicine if you'll just let me out. Because guess what? They're not going to take their medicine. I want to see that they have started that. So we make them start their meds in jail if they're in jail. And if they're in the community and they're not on meds, I need to see that they have started their medication before I will actually accept the case. And oftentimes I'll tell the attorney, hey, this is what I need. And we will reset their court case out far enough to give them the opportunity to do that. So for this individual today, he is represented by the public defender's office. I called Stephanie. I said, hey, I saw him. He's pretty hesitant about medication, but he said he would do it. I gave him the number. He said he would call. He didn't want to call with me. He's going to call tomorrow. Not sure he's going to. If you will reset this out to see if he does, I'll consider taking him and we'll go from here. So I try really hard to meet people where they are and get them to where they need to be to come into the program. We're not perfect. I'm not perfect. Ashley has known me for 20 years, dang near. She can tell you I can be really abrasive, but I'm blunt and I'm honest, and I'm just not going to put somebody in a position where they get into a program and they flunk out of it and they have worse repercussions from that than they would have on the front end if they just said they didn't want to do it. So I try to avoid that.
We had a question, Trish. If when participants do participants in mental health court have access to you specifically while in the going
Well,
through?
they typically avoid me like the plague.
Okay.
So I do their initial assessment, and then we have 4 people in our office that supervise the cases. We have 2 males and 2 females in our office. We are a relatively diverse group. We try to get people from different backgrounds, different faith-based, different appearances, all the different things so that people are comfortable. And overall, I try to fit people where I think they will do best. Sometimes it's based upon census and just trying to even out caseloads. But if I have somebody that I know is not going to work well with a female, I'm going to put them with a male and vice versa and stuff like that. I'm always in the office. I like to tell people I'm like the Walmart greeter. I like to stand out in the lobby of our office and tell everybody hi and how's your mama and how's your cat? What'd you do last week? And let me see your calendar and have small talk. But when it gets down to the nitty gritty, if they're coming to see me, it's usually because they have gotten into it with their case manager and somebody has to come in and say, what you're doing is not right. You need to get it together or you're going to go to jail. Like stern conversations that I've been doing this a really long time, so it doesn't bother me to have, and other people might shy away from. Or their person's not at work and I'll pick up and see them, in between folks or whatever. And then I have some clients who never come in, that they don't poke their head in my office and come in and say hi. So I'm there, I'm in court with them. I'm at the office every day and I'm loud. Nobody can ever say, hey, Trisha's quiet. I didn't know she was here. They know I'm there and they talk to me if they want to, but I don't force it. So I'm there.
All right. Thanks, Trish. Do we have any other questions?
I have a question. You were saying today about the guy not wanting to take his medicine, and then he said he would. So, if someone starts taking their medicine and you enter them into your program, and then everything is going fine, and then they decide to stop taking it because, like you said, they feel better, does that automatically kick them out of that program, or do you work with them to get them back on the medicine so they can complete the program in the drug court?
So it really depends on the situation. And I'll give you some examples because I think that's the easiest way for me to explain it. So we had a gentleman in our program who was with us and was all the way in I think he made it to phase 5. Like he was close to graduating and decided he was no longer going to take his medicine. And he got so unwell so quick that we couldn't, he was a danger to himself and others. Like when he's a violent person when he gets unmedicated. It was bad. It was real bad. So we had no choice but for him to go into jail. We tried to avoid that. When he went to jail, he still refused to take his medication, and his cases had been transferred over open, meaning we were seeing him on a pretrial basis. And we started questioning whether or not he was competent to actually be kicked out of the court and go stand trial for these felony charges he had. So what we did is the attorney sent him out on a forensic evaluation. He went to Vanderbilt and he's actually at MTMHI, has been there for probably 7 months. And every time they think they've got him in a better place, he pops off and stops taking his medicine again. So we're working with him. We've not terminated him. We're not looking at him facing those felonies. We're trying really hard. If it's someone we had a young lady and she felt like she was better and she didn't need the medicine. So she just quietly stopped taking it. So it was a little while before we realized it and we started seeing symptoms. So we sat her down. Brandon sat her down and was like, hey, such and such, we've noticed these changes in you and it seems like something's going on. So I called over to the co-op and I talked to your case manager and they said you hadn't picked up your medicine this month. So we're worried that you're not taking your medicine, and had like a really in-depth conversation with her about why she stopped them and things like that. And it took her a minute. She didn't just based on that conversation say, I'm going to take my medicine, but she had her status date in court, I think the following week or maybe the week after that. And when she came to court, the judge told her, if you don't need medication, then you probably don't need to be in mental health court because our court is set up for people who have pretty serious mental health issues that will need to take medicine the majority, if not all of their life, the majority of their life. And we respect your decision if you don't want to do that. But if you're not going to do that, we're probably going to have to put you out of the program. And these are the legal ramifications of that. So then the attorney sat down with her and went over what that would look like. And the next day she went and got put on her medicine. So it really depends. If it's just an adamant, I'm not taking my medicine and there's nothing you can tell me any different, then yes, they will get we call it a termination order. I know termination sounds really mean and terrible, but we will discharge them from our program. And depending on how the case was transferred over in the first place, that really plays a role in what would happen next. And I can go through that if that's of interest to somebody, but I don't want to drag y'all down the pits of things with me.
I have a question.
Yes, ma'am.
A few minutes ago, it sounded to me like you described my son. My son is at Middle Tennessee Hospital, and he's been in the mental health court for a number of months. But this is my question. He does not want to take his medicine. He doesn't feel like he needs to take it, and he doesn't feel like he's sick. That's the problem.
Yeah.
I'm not ill, mama. There's nothing wrong with me. Okay. So when we have that situation, what is your response to that? Because this last time that he was sent to jail, he hadn't done anything other than didn't take his medicine. So, and that caused a whole thing, which I don't want to discuss that here because I'm not trying to discuss that here. I'm really genuinely trying to save my child. But anyway, how do you respond to that? Because that in itself, when a person with schizoid affective disorder or schizophrenia but truly believes they're not ill, that's another illness.
It's a common. Sorry, go ahead.
Mm-mm.
It's a very common occurrence. I mean, this is not something that is unique to one individual. We see that across the board. And I want to talk in very general terms because I don't ever want to put somebody's business out there. So I'm going to be very general. But in situations where a person is refusing their medications, how we react also depends on what they're charged with. And we have a district attorney on our treatment team, and they are pretty easygoing about, they let me accept cases that they probably shouldn't let me accept if we're going on the rules that the state give us. However, when it comes to certain types of charges, if the person is not compliant with their medication, regardless of the reasoning why, the district attorney's office has to step in and play their role, which is community safety. And when someone is charged with felony charges, even though we're trying not to get them prosecuted and we don't want them to go into custody or go into prison or jail long term, at the end of the day, they have to make a tough decision that at some point they either have to prosecute the case and pretend like mental health court never happened and subpoena like the officers that were involved and all the things and start over just like mental health court never happened. And then that person has to take their case to trial or whatever happens with it. And in cases where the individual where competency is being questioned, specifically where we're concerned that maybe they're not making sound decisions and maybe don't understand the legal ramifications, that's why we use the competency process, because we don't want and can't legally prosecute someone for things they can't manage, if that makes any sense. And so that's why the example I gave, who may or may not be your family member, has been out there so long, is because they have not yet said he's not restorable, meaning he's not competent and can't ever be competent. And they can make that determination. And if they rule he's competent at some point, and this person says, I want to stay in mental health court, we'll welcome that person back and we'll keep rolling on until we finish and can get these cases dismissed and expunged. If they say he's competent, we think he's prepared, you know, he can be in front of the judge or whatever. And the client says, I'm competent, but I don't want to ever deal with mental health court again. At that point, then he would just go through the regular criminal justice system. But if they deem him or deem the client to be incompetent or not competent and not restorable, or even if they think they may be able to restore him someday, that person then will stay at the hospital either until they are competent or until the hospital feels like they are no longer a danger to themselves or others. So that really takes it out to be a clinical decision made by mental health professionals rather than the legal system. So there's different avenues that can be taken. I know that was like a really generic answer because I don't know the full details of it, but that there's different options and we're kind of at an impasse on it, trying to figure out what to do next.
Just you put in the part about maybe a danger to himself or to others. Kind of helped me in my son's case understand why he was taken to jail. The only problem I had with that is he didn't take his medicine for the whole time he was out there, so there was a problem.
When you say out there, you mean in the jail?
Right.
Right, because they can't force medications in jail. And really, they try not to force them in the hospital anymore. There's a lot of ethical dilemmas and arguments that can be had about forcing medication. So a lot of times people will decide in the hospital that they'll take it or they'll get, you know, to a point where they do force them. But that's why people get sent to the hospital and they're there for a really long time, unfortunately, is because they're making decisions that are hindering them from being released and moving on with their lives, even though they don't realize that's what they're doing to themselves. I mean, I don't think it's a purposeful move. You know, it's not somebody giving you the middle finger and saying, screw you. It's truly just not being able to make a good decision for themselves. And so they end up at the hospital, but that's really what the hospital's there for. And I'm not as well versed in like Jillian's law and the competency stuff, but I have a really good friend who is, and they've explained it to me several times. You know, and because of Jillian's law, people who are deemed not competent, not restorable, they are kept at the hospital at this point because of safety concerns to the community and whatever their crime may have been.
So Jillian's law would be a part of what's going on, or he's under that sum or could be under that sum?
Futuristically, if found incompetent, yes. But at this point, specifically, that client has not been found incompetent. Does that make sense? And I'd be happy. You can call me, and I've got a conservator. I can have a full-blown conversation. But I don't want to give out his business and be too detailed on here. But just to kind of give everybody an idea, because this happens.
Part of the problem that I have had is that I am his conservator because he can't manage in life. And part of what I should be able to speak about is his medical care. And I have a hard time being able to do that.
Yeah.
I have a hard time for agencies and for even the hospital to understand that I have that right, because this person cannot, they can't make good decisions in life, much less good decisions for your mental health court.
Yeah. No, I completely understand. I know the challenges, trust me, I do.
All right, we should talk. Thank you so much.
Yes, ma'am. It was good to see you again, by the way.
Okay, good.
Do we have any other questions for Trish tonight? Trish, I'm going to say that indicates that you were very thorough tonight, very helpful. I really appreciate that you are willing to have people contact you directly. Some agencies do have different boundaries, but we do appreciate the work you're doing in the mental health court system. We appreciate your time tonight. Uh, Before we adjourn tonight, I did want to mention that this is a part of what we do at NAMI Davidson County. We do hold virtual education sessions throughout the year. With the fiscal year changing come July 1st, we do have some upcoming sessions, but I'm always encouraging our members and the public to contact me at outreach@namidavidson.org for suggestions. If I can find a presenter on an appropriate topic, we will have a session. But we want to know what you all want to take from these sessions. But I do want to let you know that tentatively we do not have the official dates yet, but in September we will be having Black Mental Health Village out. They're one of our community partners. They're going to be talking about mental health in the Black community specifically. In October, we'll be having someone from Park Center come out and talk about SSI and SSDI benefits. That is something that we get a lot of questions about through our helpline. So we'll be having someone out in October for that. And we already have our good friend, Dr. Joseph Pandit, who comes out at least twice a year. Usually he visits our family to family class, but this year we're going to be doing a session in January on understanding psychiatric medications. Dr. Pandit, Joseph is a huge supporter of NAMI and is very open and honest about medications, both the good, bad, and indifferent side of them and the system of getting the medications and whether you need them or not. But we have those set up already tentatively, but we are looking for more topics and presenters. So if you have uh, a topic you'd like us to discuss, please reach out to me. Uh, I want to let everybody know that the benefit of registering for our education sessions is, as Trish mentioned, you will receive after the session is over, the PowerPoint that Trish supplied that she was using tonight. Also, I will be uploading the audio version of this talk onto our YouTube channel, which is NAMI D Info. Everyone registered is on our newsletter. So on Monday, there will be a link to it, but you can be proactive. And I would say by tomorrow afternoon, take a look at NAMI D Info on YouTube and you'll be able to hear our session tonight. So again, I want to encourage everyone to support these programs. We do offer them free to the community, and we appreciate what everyone is going through. It's not always easy when you come to NAMI, but I hope that we help fill the gaps and we help ease what this journey is like, whether you're a family member, friend, loved one of someone with lived experience, or as in my case, a peer who does deal with mental health issues. And I will say there was a time in my life that I was not sick. It was everybody else's problem. And thankfully, I have found a better way to deal with it. But not all of my peers are that lucky to come to that realization early enough before things turn south. I'm very lucky that I was not in court more often in my 20s and 30s. But if I was, I would be glad that services like what Trish is doing are available in Davidson County and throughout the state of Tennessee. So I want to encourage everybody to say thank you to Trish for taking time out of her schedule tonight to talk to us. And I thank everybody for supporting our NAMI Davidson County programs. So with that, thank you all and have a great night.